Welcome to Zero Privacy Post-Dobbs, How the Threat Landscape Has Changed. This is the first of a free three-part webinar series presented by the American Bar Association, Civil Rights and Social Justice, CRSJ, and Science and Technology Law, SciTech, sections to boldly explore digital threats to privacy. My name is Ruth Hill-Bro, and I'm a past SciTech section chair, a senior advisor for SciTech's Privacy, Security, and Emerging Technology Division, and special advisor and immediate past co-chair of the ABA Cybersecurity Legal Task Force. SciTech and CRSJ have jointly developed today's program and the three-part webinar series to bring together thought leaders, highlight best practices, and identify next steps in an area where change is the only constant. So please visit ambar.org/encryption for updates on these programs and related materials and resources. Now, today's 60-minute program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. And if you don't see the controls at the bottom of your screen, please ensure that your screen isn't idle. Our moderator will monitor the Q&A, and the panelists will do their best to address your questions, time permitting. We'll share a recording of this program with everyone who's registered so that you can share it widely with your networks. And I'd like to begin by introducing our panelists. Willmary Escoto is based in Washington, D.C., an attorney and U.S. policy analyst with Access Now, where she leads their data protection and privacy portfolio. She previously served as the Director of Policy and Government Affairs for the National Hispanic Media Coalition and was hosted by Public Knowledge as a Google Policy Fellow in 2016. Nicolas is based in Indianapolis. He is the Hall Render Professor of Law, Indiana University Robert H. McKinney School of Law. And he's also the Executive Director, Hall Center for Law and Health at Indiana University Robert H. McKinney School of Law. His research interests lie at the intersection of medicine, law, and information technology, and he has over 75 published books, chapters, and articles. He's also a permanent blogger at Harvard Law School's Bill of Health, and currently is working on a major project identifying legal barriers to improving harm reduction and treatment for persons with opioid use disorder. And then our third speaker and also moderator, Lothar Determann, holds a JD and JSD equivalent from the state of Berlin and qualified for 10 years as a law professor at the Free University of Berlin before he started practicing in 1999 at Baker McKenzie, where he is a partner based in San Francisco and Palo Alto. He's a member of the German Association of Constitutional Law Professors and has taught 2 to 3 courses every year on privacy and technology law topics in Berlin since 1994 and Berkeley since 2004. He's admitted to practice in California and Germany. Now, as we get underway, I'll provide the usual disclaimer that goes with these titles. The views expressed here by the panelists are their own and not necessarily those of the entities for whom they work or have worked, and none of their comments should be construed as legal advice. Now I'll turn the program over to our moderator and panelists so we can get those insights on how the privacy landscape has changed post-Dobbs.
Thank you so much, Ruth. On our topic and title, I prepared a few slides that I want to share and see if my screen setup works. And I think I have to swap this again, huh? Can you see my slides or my? This sounds good. So we have zero, privacy, post, and Dobbs, and we'll talk about how the threat landscape changed. The question mark on zero privacy is one we'll explore a little bit, but just let's talk about the topic privacy itself. When we prepared for this, Professor Terry said we should assume a lot of this has been read, but I'll just remind ourselves it is a very broad and fundamental right to be left alone by the government, by other people, by companies. It's the right to self-determination, autonomy over one's thoughts, body, personal data, and it means different things to different people. I think the saying, there's no privacy without security, but there could be great security without privacy, illustrates that we tend to agree on security. We want to protect our information, ourselves, our property, our bodies from unauthorized access. But on privacy, it's a more conceptual, a more amorphous right. During the pandemic, I recorded a little music video on what privacy means to me, and has all the jargon from my law school classes. If you put my name into YouTube and privacy, please, you might get a chuckle out of it. And I think that's enough on privacy for the introduction, and I'll turn to Dobbs. Dobbs versus Jackson Women Health Organization, 2022, is a Supreme Court case. It held that the Constitution does not confer a right to abortion, and it overturned two earlier decisions that did find such a right in the Constitution. The judges returned the authority to regulate abortion to the people, the elected representative, the legislature, and the decisions here that were overturned, Planned Parenthood versus Casey, 1992, Roe versus Wade, 1973, have been very core to the debate on how much privacy is a human right, is guarded by the Constitution versus is given by the legislature. The 9 justices said this is not something that judges should decide by themselves. It should be the people who are deciding it. They pointed out the balance of power in our constitutions and wanted to return this decision-making back to the people. They said when the Constitution was written, we have one of the oldest living constitutions in the world, probably the oldest that is still in place. The founders and authors of this constitutions had a different view of privacy. We have the Fourth Amendment that protects the home as a castle. Here to be seen, one of the founders' home behind a river and lots of trees, and that is one idea of privacy. It's not the world that we all live in digitally, where we're interacting not in a physical home. The private effects to be protected from the British tax inspectors are less on our mind, and the question that the justices had to grapple with is the Constitution a living thing that is going to be developed and interpreted by judges in light of present day challenges, or is this something that should go through the constitutional and democratic process, because the people could also change the Constitution? And the decision Dobbs said, this is not in the Constitution from back then. This has to be decided by the people now. Takes us back to the zero privacy code that Ruth likes. Ruth and I have practiced for a while together, and I remember when she joined our firm and she wrote a fundamental book, Online Privacy, that Online Law, and she wrote the privacy chapter that I had read before I came to the US, came to Baker McKenzie. And it was a time when the technical foundation of the internet made it already clear to people that it will be very difficult to protect privacy in the sense of my home is my castle, just be based on how computers work, how to make connections. And there's this famous quote by one of the technology leaders of the time, the company that made all the servers that were the backbone of the internet. He said, there is no privacy on the internet, get over it. Now let's turn to post-Dobbs. What's changed? Based on the decision, there is reduced privacy protection in the US Constitution. That means less protection of the individual person's privacy, autonomy against the government. That's how our Constitution works. It protects against the state, against the legislature, the executive, and the court. So where the court is handed back privacy to the legislature, it'll be the majority, and majority can decide against minorities. If there's not a constitutional protection like in the Bill of Rights, which was a bit of an afterthought back when the Constitution was written, then the majority can make decisions that affect minorities. Also, the court made the point that it goes back to the states. That means There can be different decisions made in different states. And as a consequence of Dobbs and in our post-Dobbs world, the legislatures have been very active, and they've been passing laws restricting abortion more than before Dobbs a state could do. And at the same time, a number of states, including my home state of California, has passed laws with extra protections for privacy. California passed a law that prohibits companies from turning over information to other states who want to prosecute individuals for pursuing an abortion or showing interest in abortion. And so there've been heavy legislative activity, which is exactly what the Supreme Court said should happen in order to form a new view of how privacy in the United States on this point should exist. And then also post-Dobbs, there are still existing federal and state privacy laws. They are not being invalidated, they're not rewritten. The question whether they should be federal or state hasn't been changed. And here in the United States, there are literally thousands of privacy laws already. In California, in 1972, the people with the popular ballot initiative added a right to privacy to the Constitution. That constitutional rights continues to exist in California, and other US states have a right to privacy in their constitutions, protecting individuals against the local legislatures. And the local legislatures, particularly in California, have passed numerous laws that protect privacy in the private sector against companies. And there are literally hundreds of laws on the state level here. And on top of it, by way of a popular ballot initiative, we've gotten a very comprehensive EU GDPR-like set of privacy regulations in California in the form of the California Consumer Privacy Act. All those laws continue to exist post-Dobbs and put out there the environment, the background, if you will, for our question that we want to explore on our panel, that is there zero privacy post-Dobbs, and how has the threat landscape changed? With this little introduction and overview, I want to ask Willmary, how has the threat landscape changed post-Dobbs based on the decision, as a reaction to the decision, and more generally within the United States with our existing framework of laws and societal realities?
Thank you so much, Lothar. I'm happy to jump in, and thank you, Ruth, as well. I also want to just say, I'm very appreciative of the ABA section of Civil Rights and Social Justice and Science and Tech Law section to be hosting this, and for everyone who's joining us today from home. And so, the last few years has really been a culmination of a crisis that many people saw coming, and I'm sure Nicolas will speak on this later, but for the general public, it was kind of like waking up in the middle of a nightmare, and a wake-up call for many folks who didn't know the nuances, right, of the data collection practices and how our data really is gold. So really more seeing kind of the value behind our data and how deeply that's rooted in our daily habits of even protecting our data. We're seeing that has begun to evolve, and questions are starting to be asked. The title of this section, right, is Zero Privacy. And as you mentioned earlier, for many people in the US and abroad, Access Now is an international organization. So we do have partners or offices in LATAM and the MENA region. And so what we're seeing really just kind of across the board is it is a relatable sentiment for many people, that sense of helplessness, also in a sense, surrounding our data, and it extends beyond Dobbs, from corporate and government surveillance to data brokers and the use of certain technologies to monitor and track individuals. Our privacy is in question, and it hasn't been in question for the last couple of years. And so when you start unpacking what the Supreme Court ruling in Dobbs means for human rights and digital safety, and really what's next for collective action, you can kind of widen the lens there a bit beyond Dobbs to see also the importance of combating, right, the nefarious data broker industry. And so you ask kind of what's the impact, how things have changed. And I think that there's a deep understanding at this level that, you know, our private lives are constantly surveilled and monetized, and everything from a person's whereabouts to their online search histories can be sold and used against them. In the case of Dobbs and its impact, you know, law enforcement agencies and prosecutors and in states that are hostile to abortion or have criminalized abortion, they can seek access to geolocation and other data to identify people who are seeking abortion. So when we're talking about harm, we really need to be very direct and talk about who this impacts, you know, marginalized communities, vulnerable groups. And the threat to privacy, is even more dangerous for Black and Latina women, the disabled, immigrants, low-income people, and really other communities that have been historically discriminated against and exploited. And so with the right to abortion, that's pretty much gone, evaporated. People seeking this type of reproductive health care, they're forced to go to such great lengths to protect their privacy. So what does this mean, right? What does this touch on? It includes encrypted communications, deleting your history. So you can see how the discussion of how important encryption comes into play. The concept of data protection and the right to privacy, they're interrelated, but they are different. Where we're at currently, I think it's about 160 countries, they recognize the right to privacy. Yes, so sorry, I blanked out for a second. My puppy was licking my toes. I forgot to put him away. Anyways, and so I think what we're really seeing right now with the Dobbs decision, it is how it poses a critical threat to privacy rights, and how there's just this wide latitude that law enforcement has in purchasing sensitive information. We know that digital evidence has already been used against pregnant people in the US, and there's been reports of data brokers selling location data to other people who aren't police, right? So that's equally troubling. And so, I know we're going to get into this, but I did just kind of wanted to highlight a few things when we're talking about the landscape, right? And what this touches on, and kind of the spider web of data and everything that data impacts. And so, our data can be used against us in a number of ways. It can be used to deny us healthcare, including abortion care, to discriminate against us in employment and in housing. And, just last month, I believe it was, the Washington Post reported that it was a conservative Catholic group that spent somewhere near like $4 million. $4 million they spent to buy location data from private data brokers to identify gay priests and report them. And so this is a major story. It goes beyond people seeking abortions, but it highlights what it says about how easily our data can be used against us. Everyone has their reasons to keep their private lives private. And so, Congress has failed to enact federal data protection regulation. When you combine that with these shady data broker practices, and in many cases, just complete unethical practices by many entities, we're in a world where so much of our data, significant portion of our data, is collected without our knowledge and our consent. And so, I'm really excited to kind of dig into this and talk about this more. I know Nicolas has a wealth of experience specifically on HIPAA. And so I'll stop there.
No, thank you, Willmary. No, that's great. So tying this back to the overview I gave and making the transition to a question to ask Nicolas in a second, you're pointing out that this amassing of data is not post-Dobbs. It's been going on for a long time, right? I have the quote up there. You have no privacy. This is from 1999. This is not new. What is new is that a shift has occurred in when a woman can terminate a pregnancy and whether states are going to be actively prosecuting women and men that are involved in abortions, and brings to the attention of people not only that all this location data and other data that is being stored and traded about them can be now used for a very no purpose, whereas before they might have said, well, I have nothing to hide, no big deal, doesn't concern me. And now they're thinking it concerns me relating to abortions, but other things too. You mentioned sexual orientation, something that the US is becoming increasingly progressive and liberal and open to it. That is already mentioned in the Dobbs decision too, as something that may not be as much protected in the Constitution as previous justices had thought and written. And therefore, a lot more people are starting to think that are minorities in certain areas. Wow, these consensus may be eroding. The government may use the state against me, and all these private entities that are trading my data may now have a completely new threat landscape developing for me. Nicolas, Willmary already set this up for an area that you are a renowned expert on, and that is health privacy laws. And we mentioned a law, HIPAA, that is not in itself a privacy law, but there are privacy rules under it, and it is a federal law, and it's not a very new one. What role will it play in our threat landscape? Will it protect individuals from changes post-Dobbs? How significant is it, and what is the impact for our discussion today of HIPAA?
Well, that's the $64,000 question, Lothar. Thank you for it. And I too want to thank Ruth and the ABA sections for this opportunity. I want to start actually by going back to something you said in your introduction, Lothar, about Dobbs. I mean, for clarity's sake, Dobbs didn't touch privacy. It didn't mention privacy. Privacy has not been part of the SCOTUS abortion jurisprudence for several cases, most recent cases. In sending the abortion issue back to the states and allowing states to prohibit abortions or severely restrict access to reproductive services, the impact of Dobbs for our purposes today is that it opens up the question as to how heretofore private information involving reproduction will find itself into the hands of law enforcement and prosecutors in enforcing, in so many states now, these incredibly restrictive abortion laws. Now, you note to your direct question, you note that HIPAA's been around a while. Yeah, it's almost a quarter of a century old. And it's always had sort of its quirks as well as its features. For example, it describes itself as a privacy rule, but doesn't protect privacy at all. It, in fact, is a confidentiality rule. It doesn't really have a strong statement of data protection principles that you, Lothar, would be used to from reading the European data protection regulation. Rather, it has a list of sort of exceptions to confidentiality. So it is an exhaustive list of when people can breach confidence, if you like. And the other key thing, and this is really important for the work that Willmary is doing in location services, is that the HIPAA protected model is what we would call a sectoral model, in that it regulates traditional healthcare providers, but it doesn't protect all health information. So it only protects health information that's being held by what the regulation calls covered entities, which for our purposes means health insurers and healthcare providers. Now, all of those weaknesses have been illustrated or amplified after Dobbs. And I think all of them implicate the question of trust. Trust is fundamental to the physician-patient relationship. Let's face it, our bargain with our healthcare providers is we will provide information regarding our healthcare so they can treat us, but in exchange, they're going to keep it confidential. That's the core. And HIPAA has always stood for the proposition that the government including after the 2009 HITECH Act, state attorneys general, was prepared to protect our health information against overreaching providers and third parties. What we hadn't reckoned with was that the government, or at least a large number of state governments, would become the data assailants, seeking reproductive health records to use against their citizens. And I cannot overstate this fundamental shift. Abortion restrictive states have previewed their attitudes with sort of mandated ultrasounds, physician scripts, and so on. But in many places now, they are in the process of moving from being reproductive data protectors to assailants of persons and their personal information as they implicate reproductive services.
So, Nicolas, as you point out, HIPAA doesn't really have privacy in the title, right? It's health insurance portability law. The Constitution doesn't have.
Well, that's the statute, all right? That's the statute, and part of the statute gave the secretary power to create the privacy rule, the security rule, and after 2009, the data breach rule.
In order to protect the patient data, make it more palatable to everyone, to port your health insurance and take X-ray and other devices along. But to come back to your point, what is privacy, or how is this even covered? So HIPAA in the title of the statute was not a focus to be a privacy law. It had these additional protection. The Constitution doesn't use the word privacy. The decision in Dobbs does mention privacy quite a bit, and it notes that Roe, the decision that it overturned, found the right to privacy in the Constitution a core right of autonomy, privacy to the individual, including a woman's right to decide within limits to terminate her pregnancy. And there is a lot of common ground on that. Once the child is born, everybody agrees it's homicide to kill it. There is also some consensus about that women are free to decide whether to have children or not. And then there is a lot of divisiveness about the question, when exactly does the government get involved regulating the women's decision whether to terminate the privacy, to terminate an abortion? And that is what this decision said should not be decided by 9 justices. And the question now is, with this protection against the government lost, or against the legislature lost in the court decision, what will this mean for all of us with our core rights to privacy? And we have different interests in that. Willmary initially already mentioned a number of threats, and we've covered some of them. Question now back to Willmary, what should additionally happen in terms of changed legislation? What other threats should be addressed? You threw out data brokers. They've been around for a long time. Here in California, where we do regulate them and they have to register with the California Attorney General, they are recognized in the statute of making an important contribution to our economy. It is efficient that there is some trading of information. The sharing of information is fundamentally a good thing. It enables companies to innovate. It enables the government to govern us. Is it per se necessary, just as a consequence of Dobbs, to regulate data brokers differently, or is it maybe a question for each individual how to handle their data differently? What is your sense there, Willmary, and what recommendations would you give?
Absolutely, Lothar. So the first thing I'll say is that the burden shouldn't be on consumers, first and foremost. And if you're asking, what do we need? I think we need stronger federal privacy protections with prescriptive guardrails for the public and private sectors. We need laws that limit what information companies can collect about us, how they can store it, who they can share it with, and what kind of consent they need to share it. So we also need greater clarity on law enforcement's practices of purchasing commercial data and their ability to sidestep legal protections against unreasonable searches and seizures. And so I think that, when when we're talking about, and this is just a thought that I was tinkering with, when we're talking about balancing interests, it's really important to talk about the harms to specific people and communities, and that we're not overlooking harms. And just how easily available personal data to government raises significant risk to Black and Brown and Indigenous people. And even when companies promise to anonymize our data, that data can be easily identified. There's been historically a number of breaches and just a number of pitfalls. So we've seen that self-regulation. Just simply, candidly, it has not worked. And so, we're seeing already examples of platforms handing over private messages. Last year in Nebraska, I believe it was Facebook handed private messages between a mother and a daughter, and they were criminally prosecuted for abortion-related charges. Vice exposed, again, last year, I believe it cost under, I think it was $200, $160 to get a week's worth of data when people where people who visited Planned Parenthood came from, how long they stayed there, and where they went afterwards. So just think about that. Like a week's worth of your data costs under $200. And so, the biggest takeaway that I want people to know is that even though it's happening, the right to privacy shouldn't have a price tag. There's just, when we're thinking about the evolution of abortion services and how abortion care has changed dramatically in the past 20 years, a lot of abortions, and I wanted to say most, I'm happy to cite the studies that I've been reading, but the majority and a lot of abortions, and I'm sure Nicolas can speak on this as well, are done through medication. And so that leaves a digital trail. And so when you order medication online, your information is stored online, your location data can be tracked, and all of that data can be used to identify and prosecute you. We're seeing data collected by online pharmacies and social media posts, and law enforcement requesting, message and search logs and building those cases against women. So I think that, there has been some legislative movements, some legislation that's been introduced that, could be a solution and provide those guardrails. But until we do, it will have a chilling effect on people seeking reproductive health care. And so I think, I'm happy to also talk about, I was thinking about a lot of the movement we've seen already. The subcommittee on oversight and investigations, they just did a hearing last month on who is selling your data on data brokers. Just last week, I believe, what day is it? The 16th, 6 days ago, the Bipartisan House and Energy Committee, they wrote to heads of data broker companies, and they asked for information to understand how data brokers purchase and use and sell American data. The White House came out with an executive order last year. And there's also initiatives that industry has taken, but it just isn't enough.
No, this is, isn't that a good thing? And I want to turn to Nicolas. You're a professor. Isn't that great? Democracy at work. The Supreme Court sends it back. Was it maybe the wrong choice that 9 justices, of course, we all think highly of lawyers because we are lawyers ourselves, and we think that the justices are really at the top of our profession, the most qualified and esteemed and sophisticated ones. But we also feel we believe in democracy. This is such a controversial topic, and Willmary is very passionate about it, and so are people on the other side of this discussion. And it varies within our great country. It's a big country. It has 4 time zones. I'm from Germany, much smaller country, about the size of California. Isn't that a good thing that there is now an active debate? People are looking into it. There's legislative activity. Wouldn't it be cutting democracy short if the federal government steps in, as Willmary is asking, and regulates it the same for the entire country, where people in California, in Utah, in Mississippi, in Maine, just to name some states across the country, maybe have very different views on this and want to have this regulated slightly differently? Isn't that a good thing that democracy is at work? There's discussion, there's legislative activity, people will be energized, they'll go to the election and express their views on it. How do you see that Nicolas, from your perspective as a professor, as a citizen?
Well, I think you're tempting me into a high school civics debate. And I'm not sure that's particularly useful. This was clearly a most political decision. This had been a decision that had been carefully crafted by a series of heavily financed organizations who were not interested in democracy. It has been a decision that has been made with the context that the Supreme Court must have understood of many state legislatures that had been carefully, again, crafted as to what reaction they would take if given freedom. We could see that from the trigger laws that were passed beforehand. And it's a decision that, whatever your views of democratic process, was made in the context of overwhelming public support for reproductive services, abortion services, and more recently, as we've seen with regard to abortion medications. I think what we need to concentrate on are sort of the privacy issues that have come out of this. We're not today going to reverse Dobbs or decide whether it should be reversed. I think there are three sorts of data fights that have come out or are in the post-Dobbs world. The first is, as we've already discussed at length, prosecutors seeking location data and other non-HIPAA health data to prove that a patient underwent out-of-state reproductive services. And that raises all those questions of extraterritoriality that Justice Kavanaugh raised in his concurrence, and so on, the right to travel, these new state information blocking laws that are popping up in some states such as California. Next, and again, Willmary has very well introduced this, prosecutors seeking device and other data to prove abortion or abortion medication seeking. So texts, search engine requests, and so on. But I think the big shift for me in our privacy landscape, in our HIPAA landscape, is that state prosecutors, law enforcement, will actually be looking to leverage traditional medical records, the core records that we've always protected by HIPAA, to use against doctors and patients. Prosecutors will seek to mine health records to investigate whether life-saving abortions were truly necessary, to flag doctors who perform abortions at a higher rate, cases involving miscarriage in which there is a suspicion of self-managed abortion. All of these traditional health records may contain that kind of information. Now, HIPAA has always had a sort of this good confidentiality rule, and there are 20 million people who work for healthcare providers in this country. It's a massive industry, and many of those simply cannot resist taking a look at the records of their co-workers, their ex-partners, and to that group, I think we're now going to add a whole bunch of what will be self-described whistleblowers who will be sort of searching their employer data, i.e. the HIPAA data. Beyond that, HIPAA has leaks. HIPAA has purposeful leaks that go to public health and that go to prosecutors. HIPAA allows, and if you want to pull up the HIPAA Privacy Rule 45 CFR, paragraph 164512, you will see these, and particularly I would draw your attention to subsection F of that. HIPAA allows disclosures to comply, so this allows healthcare providers to disclose your health information, including your reproductive health information, in order to comply with a court-ordered warrant, subpoena, or summons, a grand jury subpoena, and in some cases, administrative requests. The rule also allows for some discovery exceptions. important when you have states that are beginning to harness private individuals to enforce their abortion laws. We're watching you, Texans, right? So this, I think, is the major change, that in addition to the data problems we've had with data brokers, with relatively unprotected health information in the hands of data brokers, the increasing value, as you well have pointed out, Willmary, of location service information, that now we have this sort of third front, which is prosecutors looking to go directly to your health record and bring out information that could be used to prosecute a physician or a patient.
No, thank you so much, Nicolas. So I see in the Q&A here, there's a lot of good commentary and questions on some of the things we already went over. We set the stage of what the decision is, what the threat landscape is, and we've gone in slightly different directions how to address those threats. At the end of the day, law enforcement does what it does. It enforces the laws that the legislature gives it. They are new laws, and they have a completely new threat. And so Stephen was submitting a question here and said, isn't it time to push for an amendment to the US Constitution recognizing privacy as a fundamental inalienable right? And that would be one way to take the void that has been created by the decision on for the entire country to put that in the federal constitution. Nicolas has mentioned the existing laws have some carve-outs. They were intended to accomplish that health insurance is portable, so they weren't, HIPAA wasn't drafted to prevent prosecutors from getting access to certain records. That wasn't the focus of the law. It was to make sure that the doctors and the health insurance companies and others protect the privacy of these records that will be shared more often. So there could be also things done on the state and federal level to protect health privacy more. And I want to turn to some of these state laws and either ask Willmary or Nicolas to tell us a little bit of what's going on. There's on the California level is the Confidentiality of Medical Information Act that was expanded to cover not only hospitals and health insurance companies that are covered by HIPAA, by the federal law, but also online service providers, even makers of hardware and software have to comply with health privacy law restrictions, and they're very carefully crafted restrictions in there. The state of Washington has just come out with a very broad law, My Health, My Data, that protects also health information on a much broader level than HIPAA does and with a different focus. And that one is post-Dobbs. It's very much informed by the decision and by the threats that come out of it. What is coming new there? I don't know, Willmary, is that one for you or maybe for Nicolas to tell us about these state laws and assess what impact they have on our threat landscape?
I'm happy to just briefly kind of just make a few points and hand it over to Nicolas. So so we're seeing a lot of state movement, right? And, you know, it depends on how you look at it. Sometimes state legislation can move at a considerably faster rate than federal legislation. So there's an opportunity to have quicker impact there. But what we're seeing is the harm to different communities. When state legislators are pushing privacy laws under the guise of either protecting children or protecting other different type of communities. And so, you know, civil society advocates, something we've been warning about for many, many years is that big tech company lobbyists are pushing state legislatures to advance weak privacy laws nationwide. So the Washington My Health, My Data Act is not the standard, right? There are weak privacy bills out there. And we don't want to kind of create an avalanche of, I don't know why this is coming to mind, but dirty snow. It just came to mind, go with it, whatever. So, you know, the quick passage of the Virginia Consumer Data Privacy Law, for a lot of folks may not know, you know, that was originally drafted by Amazon, I'm pretty sure, and had input from Microsoft. And so that illustrates this type of industry-driven lobbying fueled strategy that's taking hold across the country. a couple of years ago, the markup did a really cool investigation on existing and proposed legislation. And I believe it was something they identified, like at least more than 20 states with privacy bills that were built upon industry-backed frameworks like Virginia's or other weaker models. And routers, many of us know what that is, found that Amazon killed or undermined a number of privacy protections in, I think it was like 25 states. So there's this type of industry fingerprint that we're seeing there. And that's something that I really just want to highlight for folks. Just because there's a bunch of privacy bills out there doesn't mean that they're good privacy bills. And the My Health, My Data, that act significantly expands privacy protections for consumer health data. And it touches on a lot of those leaks or those holes that Nicolas mentioned. And something that I really appreciated the verbiage that Nicolas used, the terminology of data assailants. And that, HIPAA doesn't protect certain health information, like information that's shared on social media platforms. And, for a lot of HIPAA nerds, like Nicolas referred to himself the other day on a call. So I'm not insulting him. He referred to himself as that. Folks have been screaming from the rooftops of these restrictions that have been implemented by certain states, from the trigger laws to limits, from restrictions on counseling or mandated counseling. There's been a trail of kind of what was coming for the longest time. And so, it's great to see, Washington pass a strong bill. It'd be great to see more states pass that, but that's not the case. And so it would be great to have a federal comprehensive privacy regulation. The United States is light years behind of other countries, particularly the European Union. And if you start thinking about if we even want to regulate AI, the GDPR is a foundation, right, to the EU's work right now on artificial intelligence. So having a general data protection regulation that sets data minimization requirements on entities and requirements on data brokers is critical, not just for reining in, right, like the data broker industry or the sale of our data, but also how that data is used in AI systems. So I could keep going, but I'll stop there.
No, I'll interrupt you.
I think the reality of this is that it's highly unlikely you're going to see a state with very strong anti-abortion laws passing privacy laws that protect reproductive data. So what you're really seeing at the state level are states that are less restrictive with regard to their abortion laws, are passing sort of barrier laws trying to impede extraterritorial attacks on health information from the more abortion restrictive states. So the real question I think you have to ask is there anything the federal government post-Dobbs can do about this? And the early statements by the Biden administration were not particularly encouraging. I mean, they came out of the gate by saying, well, you have to have a warrant to get this. And we're all going, yes, we know. And they're all writing their warrants at the moment. And then the second thing they came out of the gate with immediately was, you should turn off location services. Well, that was great, wasn't it? Because clearly, if you turn off location services, that will stop cellular providers from tracking. Oh, no, it won't, will it? Oh, well, never mind. So what has the federal government done recently? Well, the FTC is poking around. I think they've got limited powers under Section 5. So exactly what they think they can do is going to be interesting. But in April, we did get a notice of proposed rulemaking from HHS. Seeking to, and I quote, provide heightened protections for another especially sensitive category of health information, in this case, reproductive healthcare services. So what they are trying to do with this amendment to the HIPAA privacy rule is to prohibit the disclosure of reproductive healthcare services or data about it for seeking, for conducting a criminal, civil, or administrative investigation, if the reproductive healthcare is lawful under the circumstances at which it's provided. All right, so they can't just attack state laws, making it unlawful. Instead, they're having to restrict it to when it's lawful. So when is it lawful under this NPRM? Well, the first type of case is they say where the care is lawful in the state where it's performed. Now, obviously, what they're trying to get to there is to stop abortion restrictive state prosecutors getting HIPAA-protected health information that was recorded in a abortion-friendly state. All right, that's what they're trying to do there. So it's really only those sort of abortion tourism cases that first case scenario would allow for.
I think
The second thing is that they have a provision that says it will be lawful if it is lawful by federal law. So that's an attempt to leverage the EMTALA provision, which the Biden administration tried to do, but that's already had shade cast on it by Texas and other states. So I think the problem with the NPRM, I know there's at least one question in the Q&A on this, is it is relatively limited. It's only going to have a minor impact, I think. And I think you can tell from the way it's been written by HHS that they expect it to be challenged. So pick your favorite district court in the north of Texas, where this NPRM will be finding a home soon.
No, thank you so much. I want to counterbalance a little bit the grim and dark views that our other panelists have painted here by, first of all, giving the European perspective. So we do have computer regulation, data processing regulation in Europe, but it is interesting to look at how the right to abortion is treated on a member state level very differently, because the European countries also have quite different views on that, and that is not the only privacy right. And if you look at a law that doesn't mention privacy, the Q&A pointed out that the Dobbs decision does have it at least 9 times. The GDPR, the General Data Protection Regulation, doesn't mention privacy one single time. That is not what that law is primarily focused on. It is focused on regulation of processing of personal data. And here in the United States, I would personally, being from Germany, having lived here and teaching privacy in Berlin and Berkeley, say that we're a little bit too harsh on ourselves in terms of saying that the US privacy regulations have failed. I think they're very specific. I think they do have problems. And I personally also advocate for a federal law that should preempt much of the state laws, because it's just unmanageable now. My book has 700 pages now covering every single California and federal privacy law, and nobody can sift through anymore. They're conflicting. The older ones don't get repealed. So there are a lot of problems with it. But I think the positive thing is they do respect relatively quickly to new developments, something that is not happening in Europe. We have a law from the 70s that is being harmonized in 95 and then recast the first time 2018. So next time we'll see something 2030 or 2040, and how that will deal with AI remains to be seen. So I wouldn't totally propagate the European approach as a solution to everything, and would be a little more positive about the solutions and the experiments that we've seen here and that are being picked up by our participants in the Q&A session. Namely, there are state laws that, taking the anti-privacy view, more interference by the government in individuals' health decisions, but also states that have gone the opposite way. And this ongoing debate at the federal level to try and find consensus for that, I think, is a work in progress. I think there is not a clear majority in neither party. I don't think privacy is a partisan topic. I think there is on both sides of the aisle very different views, and it will take some time to sort through it, but I wouldn't see it all that negative just on this one decision. All these existing privacy laws, they keep being in place. And I wanted to point out also, on picking up some of the things that are in the Q&A here, that the decisions that the states have taken, for example, requiring opt-in consent for the collection of personal information, will to a large extent make the trading of health information for marketing purposes impossible or illegal. And I think that will be greatly reduced the way it is written. In Colorado, a number of other states, consumers have to be asked for opt-in consent before their data is collected. And in with the additional measures that are being taken specifically for the healthcare provider regulators, it will, my forecast is that health information will not be used for advertising, definitely not for children. In California, we have this requirement that companies have to allow people to opt out of the use of personal information in the health sector's sensitive personal information. And we will see how much people care about it, right? Willmary gave us today the wake-up call and all the threats that are out there. Nicolas pointed out some of the limits of the existing laws, but that doesn't mean there is not a strong body of existing laws that is out there on the state level. We do have 4 more minutes, I think, and I wanted to take a look at the Q&A sections here. There were very specific ones. There was one from Nicolas here on a thought on the new HIPAA privacy proposed rule by HHS to make it harder. You've referred to it with its acronym, but what is your sense? Will that be enacted as it is? What would you recommend the audience to contribute to it? And how do you see it within the framework also of the FTC and HHS with guidance, with enforcement actions against data brokers and so on, already reminding healthcare providers that they do need to obtain consent before they, for example, have a pixel for marketing information sharing on their website? Is this going to go in the right direction, and how should our audience participate in this discussion?
Yeah, you've moved me slightly from my Grim Reaper position, Lothar. And I mean, I concede that there are many interesting state initiatives and some federal ones. I do think, however, that there are some quite difficult legal limitations on the powers that the federal government have to enact major or at least important privacy rules. I think the jurisdiction, the powers of the FTC are somewhat limited. I think HHS is struggling as to what they can do. The new NPRM, as I just told you, I think is relatively weak. It doesn't do very much, but it does do something. And I think we'll see more of that. We have some interesting federal laws on this topic, particularly that has been proposed by Representatives Sarah Jacobs and Anna Eshoo. And so we may see some more changes with regard to that, more visibility. But I do think we are in for a rocky couple of decades.
I'll have one more for Willmary also from the audience here, and then I would like Ruth to come back to us and tell us the outlook. There's a good engagement here from our audience, very good questions that will be stored, and to the extent we don't get to them today, I'm sure Ruth, Ali, Chris, and others on the organizing committee for this 3-part webinar series will pick them up in future ones. But Bruce here ask a question, maybe Willmary you would address and say, talk about the public that supported these restrictions. At the end of the day, is these a democratic decision? The audience member here, I don't know if the numbers are, I'm not fact checking, although I have ChatGPT open in my other window here, says, speak about the 51% of white women who voted for Trump in 2016, or the groups that support these restrictions on abortion, on restricting privacy rights. They're part of our country. They're voting and they have their own views of it. What is the sense on how can we find a consensus with them in the country for reasonable legislation. It's not just one view that will ultimately dictate how these decisions can be made in legislation. And if there's not a majority for a change, then there won't be legislation. Willmary, do you want to address that last question? Hopefully not with too dark and grim reaper a vision, because these will be the final words for today.
No, absolutely. So I think, I mean, it's patently obvious how difficult it has been for Congress to come to a bipartisan decision and to put forth and adopt and enact a federal legislation. I think that for the past decade, it's been a struggle. I mean, in regard to this question about who supports and the percentage of the demographics, I'm not sure how deeply I really want to get into that, because so many things come to mind that I could branch off of. I think the most concerning, again, I think the biggest concern is who are these laws impacting the most and who is being harmed? You know, if we're talking about marginalized, historically marginalized and vulnerable groups, we need to address those harms. We need to talk about those harms. We need to amplify those harms. You know, if I was watching a conference just the other day, and there was a great point. I'm happy to share the details afterwards, but it was a point made regarding, you know, women being criminalized just for the suspicion of getting an abortion. And there's no real way to test if you self-induced your abortion, excuse me. So, and you're thinking about vigilantism. I mean, we know that in America, citizen vigilantism has not worked, and it's resulted in the deaths of Black and Brown people. And so knowing this, having this historical context, that's something to also consider when it comes to this. You know, do we really want political enemies or political rivals or enemies or just snoopy busybodies having that much, you know, power or being able to maliciously report an individual and just dramatically change their life, and it, again, lead to the criminalization of them. So I think people are going to have different views on this. It is a very politically, spiritually, religiously charged discussion. And so, yeah, I'll stop there. I'm not sure, Nick, if you want to jump in on that.
I think I will not let you jump in anymore because we are at time. Ruth is coming back, but I want to thank my panelists, Willmary and Nicolas, giving an engaging talk, a lot of detail about the topics of the threat landscape, what is in the works at the federal, state level. We did talk a lot about abortion because that's the starting point for the discussion on privacy rights, but it is just one of many privacy rights of autonomy, and we've also touched on a lot of other topics. And I think, Ruth, with this series that is continuing and that has 2 more installments, there will be ample time to focus on other aspects of privacy, of security, and the digital threats for both of those, as well as the positive protections and the good momentum that we're having this debate here in our community, in our legal community, and recognizing other people's views, the interplay of democracy, but also minority rights protection in our Constitution, the balance of power. All that is something that we lawyers are trained and tasked with safeguarding and bringing out there into the world to shape the discourse, the discussion, and ultimately the decision-making and regulation within our society. And I'm grateful for having been invited by my good friend and long-year colleague, Ruth, and want to hand back the microphone to her to tell us how it will all continue.
Well, thank you. Those 60 minutes for our program flew by. I'm thinking this was an appetizer portion of what could be a 2-day conference banquet. There's so many issues that can be discussed. We'd like to thank all of you in our audience for your attention and terrific questions. Also like to thank our distinguished panelists, Willmary Escoto, Nicolas Terry, and Lothar Determann, who did double duty as our panelist and moderator. On behalf of the American Bar Association, the Civil Rights and Social Justice section, and the Science and Technology Law section, I thank you for joining us. Encourage you to register for the next 2 webinars in this free series. The next one is on June 9th at 1 p.m. Eastern Time, called Zero Trust, Encryption and Other Approaches to Protecting Private Data and Communications. So we're going to dive in on the security side of things. And then the third will be on July 20th at 1 p.m. Eastern, Zero Sum Game, Developing a Winning Approach to Privacy and Security in an Age of Zero Trust. Visit ambar.org/encryption for more information. And to register, registrants for this program will receive an email as well. Both of our sponsoring ABA sections provide webinars, publications, and other resources for attorneys, business professionals, and advocates nationwide. Members receive so many benefits, so please consider joining and becoming active in the ABA and these sections. You may do so at ambar.org/CRSJ and ambar.org/SciTech. So thank